Thank you very much. This is my first time to visit the U.S. Naval Academy. I'm really pleased to be here and to have the chance to talk to all of you. I've been assured that you're all extremely bright, so you know, I've tried to pitch the talk that way. I'm going to start out kind of speaking maybe a little abstractly, but then don't worry, I'm going to get into some concrete, you know, specific examples of what I'm trying to say. But I want to start out by giving you kind of an overview of kind of what I'm going to try to talk about. And basically, my starting position is that Chinese law. I mean, well, we all know China is different from the U.S. in many ways, but even though we know this kind of abstractly, it's not always obvious in which ways. And figuring this out is especially challenging when we look at the legal system, because there's so many surface similarities. We see institutions conventionally translated as courts, staffed by people whose job titles we conventionally translate as judge. And they talk about texts that we conventionally talk about as laws or statutes. And so the main goal of my talk today is to discuss these particular aspects of the Chinese legal system and the political system of which it is a part, that are the most different from what seem to be their counterparts in the U.S. And so if I had to sum up maybe in one sentence the main difference between Chinese law and U.S. law, it would be by saying that in China the law is not perceived as a kind of overarching authority, or as I said in the title, a kind of brooding omnipresence. I didn't make up that term. But it's not perceived as an overarching authority governing, at least in theory, everything the state does. And so what that means is that China is not, even in theory, let alone in practice, a rule of law state. So the place of the legal system as a whole in the polity is fundamentally different from its place in, you know, for example, and I only give this as an example, some place like the U.S., where, you know, as de Tocqueville famously observed in his book Bureaucracy in America, there's scarcely any political question that arises that is not sooner or later resolved into a judicial question. Now, the important thing is, I don't say, when I say China is not even in theory a rule of law state, I don't say this, you know, to condemn China or the Chinese political system. That's not the purpose here. The purpose is just to try to be as descriptive as I can, and to recognize that China has a very different history. And therefore, you know, it shouldn't be surprising to find that a country with a completely different political, legal, you know, religious history has come up with a different political and legal culture. And so its current institutions, for example, courts, are very different from U.S. institutions that appear to go by the same name. So what I mean to say is something more than just simply to talk in the usual way about how the Chinese legal system is immature or how it's weak or any of those other adjectives that people commonly use when talking about the Chinese legal system. Because I think this way of talking about it maybe misconceives what it's all about. Because if we say the system is immature or if we say it's weak, that means we're imagining it on some kind of a path towards being mature or being strong, and that we somehow can, we have some firm idea of how it looks at the end of that path. And very typically the idea people have of what the end of that path looks like is, golly, it's just our own legal system. So what I want to suggest is that we have to think about the legal system in China in a completely different way. Not as something immature that's growing towards maturity or as something weak that's growing towards strength, but really as something that has to be understood in a sense on its own terms, and not merely some kind of variation of the legal system that we imagine China should have. Legality in China is not a universal standard against which all acts of government can be judged. Instead, I think one can conceive of it as a subset of the various tools that are available, tools of governance available to the state. Now, maybe there are universal standards against which acts of the state can be judged, but then maybe those are standards of prudence or standards of morality, but they're not standards of law. Let me put this another way. We can think of the discourse of legality as a kind of a game. And the rules of the legal system game, if you're playing the legal system game, that means that you have to talk about rules of law in a certain way. For example, you have to accept this binary distinction between legal and illegal. And then what I want to suggest is that some political legal orders, not all, but some, require everyone to play the legal system game, including the government. Now, you can play it better or worse, more or less skillfully, and you can cheat, but you still have to play it. You're not allowed to say, I'm not going to play that game. Some political legal orders require that. But the legal system, the political legal order of China, I believe, does not require that. The legal system game, instead, is only one of many games that the state can play. The state in China is not required to derive its legitimacy from the law. It doesn't need legal authority to act. And so that's why very often I find that asking whether some act of government in China is legal or illegal doesn't really make sense. And when I try to pursue certain questions with colleagues in the Chinese law field about whether some act is legal or illegal, I find it ends up in a very frustrating conversation, because it turns out that asking that question just doesn't yield a useful answer. It's a bit like asking whether some act of government conforms to the rules of basketball. If you try hard, you might be able to figure out what that question even meant. And if you tried even harder, maybe you could figure out what the answer was. But the answer wouldn't be any good because the government wasn't playing basketball. It was doing something completely different, just playing a very different game. And I think one can think about talking about legality in China in the same sense. It's kind of a game. In some societies, everybody has to play it, but in other societies, not everybody. You don't necessarily have to play it. Okay, so far this is all very abstract. But I think a talk like this shouldn't be like a detective story where you wrap it all up at the end. I'm going to tell you, the big picture conclusion up front, why I think the Chinese legal system is quite different, and then give you some concrete examples of how this kind of role for the legal system plays itself out in concrete situations. Now let me start out with a very fundamental feature of the Chinese state, which is that we essentially have two principles of accountability for state organs that are possible. And one is vertical, where you're accountable to those above you in an apparent hierarchy. And one is horizontal, where you're accountable to those who are, in effect, beside you at the same administrative level. Now, if we look at the Chinese state, we can see that there are many vertical hierarchies. At least they appear at first sight to be vertical hierarchies going on, and they all are in parallel to each other. So, for example, in the court system, at the top we have the Supreme People's Court. Below that, at the provincial level, every province has its high court. Below that, we have something called intermediate courts, and at the very bottom, we have basic level courts. And judgments of any given court then are appealable to the court immediately above it. Okay, that's not a surprising result, but I'll say a bit more about the specifics later on. Then we also have what we could call maybe the executive branch of the Chinese government. So again, at the central level, we have the State Council headed by the Premier, who now is Mr. Wen Jiabao. Under the State Council, we have various ministries in charge of particular things: the Ministry of Commerce, Ministry of Foreign Affairs, Ministry of Public Security. Then below that, at the provincial level, we have provincial government headed by the governor. We have various departments, the Department of Public Security. And then at the municipal level, we have city governments headed by the mayor. So there's another kind of a hierarchy we could look at. And then, of course, the party has its own hierarchy. At the central level, we have the Central Committee. We have Mr. Hu Jintao, the top party secretary at the central level. Then, of course, provincial levels, we have provincial party committees headed by the provincial party secretary. Municipal level, we have the city party committee headed by the city party secretary. Now, when we're looking at any governmental body, and these are the people with whom we're concerned very often if we're talking about the legal system, we need to ask, to whom do its officials owe their jobs? Who do they have to keep happy? Now, sometimes it's the people above them in this apparent hierarchy that they have to keep happy, because these people appoint them and pay their salaries. But actually, more often, the principle of horizontal accountability applies. And what does that mean? That means they have to keep locally politically powerful people happy. So, for example, let's take, as an example, the city of Nanjing in the province of Jiangsu. If you are the municipal chief of police, you're the chief cop in Nanjing, and you get conflicting orders from the mayor and from the provincial Department of Public Security. Who do you have to listen to? Who's more important? And the answer is the mayor. That is, the person at the same level of government. Those are the people you have to keep happy. And as I'll explain further in a moment, the same principle applies to courts. If a superior court tells you what to do, tells a judge to do one thing, and the and the locally politically powerful people at the same level, whether they're the party boss or the municipal government boss, they tell the judge to do something else, who does the judge have to listen to? And the answer is the people at the same level, not the people at the superior level. Now, obviously, if everyone were horizontally accountable, the system would fall apart, because how would the center ever exercise any of its power? You need to have some vertically integrating hierarchy, and that hierarchy is the party hierarchy. So you go sideways, ultimately, and when you're talking about horizontal accountability, you go sideways ultimately until you reach the party people at any given level, and then they are accountable upwards. So not every bureaucracy is horizontally accountable. Some are, and some aren't. And so when you're thinking about what's going on in the Chinese legal system, you're thinking about a set of rules that were issued by some particular government bureaucracy, or some legislative body, or some decision issued by a court. You want to find out, what are the incentives of the officials doing this? What are the incentives of the officials enforcing or implementing the law? You have to know which bureaucracy are they in, and is this bureaucracy vertically accountable, or is it horizontally accountable? Okay, now we're in a position to take two ideas together and see how it plays out for courts. These two ideas are this principle of vertical versus horizontal accountability. That's one. And the second one is this idea that law has a very limited subsidiary role to play in Chinese society, that it's not an overarching ideology that purports at least to govern everything. So the main thing to understand about courts is that they are not the kind of almost mystic oracles of the law that courts are in U.S. society. They have nothing approaching the political power and the social prestige enjoyed by U.S. courts. Sometimes, and this is interesting, they appear to have the power to tell all kinds of other governmental bodies what to do. But in fact, they don't, because that kind of apparent power is really just too contrary to the way China actually operates. You might say the unwritten constitutional order of China. And in fact, it wouldn't be too much of an exaggeration. It would be a little exaggeration, but not too much, to say that really, as far as other governmental organizations are concerned, the court system is really just another bureaucracy with no more authority to tell them what to do than the post office. Now, traditionally, and when I say traditionally, I mean traditional socialist China, 1949 to 1979. We've had some changes since then. But traditionally, organizations outside the court bureaucracy really didn't think of themselves, and in fact did not have much more than a kind of moral obligation to cooperate with courts. About 10 years ago, a little more, I did a lot of research on enforcement of judgments by Chinese courts in civil cases, how they get people to obey their orders. And I came across a very interesting case from the 50s in which a court had ordered there was a defendant that was supposed to pay some money to the plaintiff, to the winner of the lawsuit, and the loser wouldn't pay it. So the court went to the loser's employer and said, deduct 8 yuan, that's the Chinese unit of currency, deduct 8 yuan a month from the loser's wages to pay a debt. And the loser's employer just thought this was unreasonable and said, well, we'll deduct 5 instead. And then the court, according to this report, the court realized its error and then agreed to 5 yuan. So what does this say? This case was presented positively. This was not presented as a report about some law-flouting government unit which should have obeyed a court order and refused to. It's presented as a case of consultation between equals, not as a struggle for power between a giver and receiver of orders. Now, fast forward to the 1980s, we get another case, very similar, where the court tells the defendant's work unit, their employer, again a state-owned or state-affiliated organization, to garnish 10 yuan a month from wages for child support for his ex-wife. This time, the employer simply refused completely. They didn't even give 5 or 6. They just completely refused. End of story. That's all I read in the story. They refused. Another interesting case from Harbin in the northeast I ran across, where we have a district level. The district is one level below the city, so a sub-municipal bureau in charge of real estate. They received a direct order from the provincial level court, that is the second highest level of court in all of China, the highest court in their province, gave them a direct order to transfer some real estate from party A to party B as part of a court order. And this sub-municipal bureau said, no, we're not going to do it because we don't think this is appropriate. I mean, they did their own investigation. They decided the court was wrong. It shouldn't happen. And they were reported as requesting guidance from their superior bureau at the municipal level, saying, what should we do when we receive a judgment with which we do not agree? So this was a difficult question. It wasn't simply, obey the judgment. It was, what steps should we take when we get a wrong judgment or a judgment which we don't agree with? But interestingly, if one looks at generally applicable law, if you look at party policy, all these various documents, it's quite clear that these people do have a duty, at least under the formal law of China, to obey these judgments and orders, but they simply don't do so. What they will do is, if ordered to do so by their own hierarchical superior, then maybe they will do so. So this is why I say that very often the court system in China is perceived by other governmental units as simply another bureaucracy, which only in certain circumstances can tell them what to do, but not many. They're really waiting for orders that apply within their own bureaucracy. So very often we have this interesting phenomenon in the Chinese legal system where we will see regulatory documents which are issued by many, many different bureaucracies, and everybody signs on. And the reason we see this is because if they don't have everybody signing on, nothing will happen. So let's take a typical, very classic problem that courts face. Again, you have a judgment, for example, against a defendant to pay some money to the plaintiff, and the defendant doesn't want to do it. What do? Well, I mean, you can throw them in jail, but we don't want to do that. We don't have debtor's prison anymore. One thing that courts will very often do is you find the assets of the defendant. You go to the bank where the defendant has some money, and you say to the bank, freeze this bank account. Don't let the defendant take any money out. And then maybe pay money from the defendant's bank account to the plaintiff. But courts were finding in China when they did this that banks would refuse to do it. They say, no, this is our client. We're holding the money for them. You can't tell us just to freeze it and pay it to someone else. That would be in violation of our obligation to our depositor. So what happens then is that the courts facing these problems then are periodically writing memos or asking for instructions to their superior courts. This eventually finds its way up to the Supreme People's Court at the top, which is not a body like our own Supreme Court, but really engages much more in administrative work and quasi-legislation. So the Supreme People's Court, realizing all this is going down at kind of the grassroots level of society, then goes around to the relevant other bureaucracies. And in particular, they go to the People's Bank of China, which was the organization that at the time the regulation in question was issued was in charge of regulating banks. They also go to the Ministry of Justice. They also go to the Ministry of Public Security, which is the police. They go to the Supreme People's Bureaucracy, which is, in a sense, maybe something very roughly similar to the Attorney General's office, which is in charge of prosecutions in China. And they get all these people to sign on to a document which says that when courts order banks to freeze assets, banks should do it. So that's what you end up with. But if the Supreme Court had said this by itself, it's not at all clear that this problem would ever have been solved. So courts tend to lack power that we might expect them to have horizontally. That is, they lack this power to tell other bureaucracies what to do. And they also don't have very much power vertically. In other words, superior courts don't have much authority over lower courts. About all they can do is to reverse their judgments. That's pretty much the extent of their power. But they don't have any power over personnel appointments in lower courts. They don't have any power over the financing of local courts. Well, if courts are so unimportant in the Chinese legal system, if courts can't really tell us kind of what the law is in the Chinese legal system, who can? Well, one answer is administrative agencies. And what do I mean by administrative agencies? I don't mean the term in the American sense. And when I say the American sense, I mean executive branch organs that are charged with carrying out some legislative mandate. What I mean here is government bodies that at the central level are part of the state council hierarchy, at the provincial level, again, are part of this group of officials who are under the provincial governor. So ministries and commissions at the central level and corresponding bodies at the local level. Now, the role of these bodies in China is very importantly different from their role in the U.S. So in the U.S., executive branch bodies typically need to be carrying out some kind of legislative mandate. Now, the courts have given executive branch bodies often a very large degree of discretion in carrying out their mandate. For example, the SEC, the Securities Exchange Commission, has a mandate to regulate the securities markets. I forget the exact words, but it's very, very vague. Essentially, to promote, strong securities markets and reduce fraud or something. All right, that gives them a lot of discretion. But nevertheless, they do have to justify whatever they do in this way. So the SEC could not tell companies listed on the New York Stock Exchange, for example, that instead of manufacturing airplanes, they ought to be manufacturing automobiles. They couldn't go that far into regulating companies. It would have to be, whatever they do has to be justified in terms of strengthening the securities markets, reducing fraud, etc. But in China, executive bodies exercise a kind of inherent governmental power, and they don't need any other justification. So it becomes very difficult to speak about the lawfulness of a governmental action in terms of whether it's justified by a statute. And indeed, if we look at very high-level laws passed by China's supreme legislative body, the National People's Congress, it also has a standing committee that passes legislation, meets every 2 months or so. If we look at these things, they often look much more like general guidelines or policy statements. They don't look a lot like mandatory commands. And indeed, one could almost say of every law and regulation that it has an asterisk, an implied asterisk at the end that says, unless some suitably senior official says otherwise. And there's many, many examples of quite clear rules of law in the Chinese system being violated by governments of lower-level governments of some sort. And maybe even violated isn't the right word, because the act really doesn't seem to be contrary to what the actual legal order of China is. Now, let me give you a couple of examples. Recently, at the national level, the National People's Congress passed a piece of legislation called the Labor Contract Law, which made it much more burdensome, in a sense, to hire employees. It required employers to, made it much more difficult to fire employees, among other things. I don't know whether it increased the minimum wage, but certainly it increased all sorts of protections for employees, which naturally makes it more expensive to hire them. And employers, both foreign and domestic, had a number of concerns about this piece of legislation, but nevertheless, it went through. Okay, what happens then? Along comes the financial crisis. And everybody's worried about employment now. They weren't quite so worried about employment before, so raising the cost of employment, they figured the cost of that would be relatively small in terms of lost jobs. But when the financial crisis comes along, suddenly government is very worried about local enterprises letting workers go or not hiring workers. They don't want workers out on the street demonstrating, because the number of incidents of unrest you have in your district, if you're a local official, is one of the criteria on which you're evaluated by senior officials. So you want to do everything you can possibly do to avoid having people out on the street making trouble, because your superiors will know about it, and that will get you into trouble. So what has happened is, at least in a few places, local officials have gone to, I know this only with respect to foreign invested enterprises because I heard this from a lawyer who represents clients who do this, but the local official comes around and says, you remember the labor contract law, all those rules? Don't worry about it. Just don't fire anybody. You know, as long as you're not firing anybody, you don't need to, you know, this other stuff will overlook any, you know, infractions you might have of the labor contract law. Of course, the question is, how much authority does this have? If the company then accepts the local official's word that nothing will happen, keeps people on, but doesn't pay them, you know, the proper wage or something, then can they be sued later on, a year later, when employment numbers are up again? Very hard to say, and certainly for foreign investors in China, it creates some big difficulties because they don't know whether they should go along with this or not. There's another example. If we look at ownership of telecommunication companies involved in telecommunications under Chinese law, foreigners are not allowed to own more than 49% of companies involved in telecommunications. Well, there's a joint venture in Shanghai where the French investor owns 51%. Now, why is that? That's because Wu Bangguo, a high official in formerly from Shanghai, thought that that should happen. And so he said this should be approved, and lo and behold, it was approved. Another example, if we look at governmental units, there is a very clear, well-understood rule dating from way back in 1979 when China passed its first joint venture law. Now, the National People's Congress, China's highest legislative authority, in fact, highest political authority under the Constitution, passed a law in which there's a very clear regulation. Everybody understands it, saying that the Chinese party to a Chinese foreign joint venture has to be in a sense, a corporate entity. It cannot be an individual human. It has to be some kind of a company. And this has been the rule since 1979, long time. Well, Beijing municipal government decided that, oh, this is too troublesome. You know, we want to allow individuals to be, we want to allow Chinese individuals to be investors in joint ventures, and so they instructed the company registration authorities in Beijing to register this type of joint venture. And not only are they, in a sense, violating this law passed by a way superior body? I mean, the National People's Congress, if you ask anybody who studies Chinese politics or Chinese government, they will tell you that the rule is National People's Congress is a lot higher than the Beijing city government. So not only did they violate this rule, but this was trumpeted as a press conference, as a bold, you know, breaking of outmoded barriers, bold exploration into forbidden territory, something like that. So now the central government clearly knows this is going on. I mean, the National People's Congress knows this is going on. But there is a sense that as long as these violations, if we want to call them that, are in a sense limited in scope or limited in territory or limited in degree, that it doesn't really count as a violation. Compliance with law is really a matter of overall statistical regularity rather than a kind of an all or nothing notion. Well, so if we can't use concepts of sort of legality or illegality, legal jurisdiction to figure out whether a government agency can do something, what do we use? And the answer is rank. All government agencies have a certain rank, and to know what that rank is, you look at the rank of their leading official. And we can assess the political clout of an agency not by looking at its legislative grant of jurisdiction. You know, not because the National People's Congress said we give the Environmental Protection Agency the authority to do X, Y, or Z. What you want to do to figure out whether they have power is to look at the rank of the top person in the Environmental Protection Authority, just to give an example. Now, if we look at this particular agency, originally it was this modest subunit within the Ministry of Construction. That is, it was a sub-ministry level unit. Gradually, the person who was the head of it, they would be someone of higher and higher rank, and now as kind of a sign that the government is putting a lot more emphasis on environmental protection issues, we see that the top person in environmental protection is, has minister level rank. But what does that mean? All that means is that this person, this agency, can give orders to people who have to obey orders that come from a minister. But there's still lots of people who don't have to obey orders that come from a minister. For example, provincial governments. Because again, as part of China's unwritten constitution, this is not anywhere in the formal constitution, but the unwritten constitution is that provinces have the same rank as ministries. And so ministries can't tell people what to do. Only ministries can't tell provinces what to do. Only the state council at the top can tell provinces what to do. Now, again, just to concretize this by a specific example, there's an interesting story I ran across in a book on environmental protection in China, where we have a city. Let's see. Trying to get my notes here. It's dark enough. There's a city called Anyang in Hunan province. And there is a factory in Anyang which was emitting a lot of pollutants. So maybe it's, I don't know, maybe it was out here, either up the top or in liquid pollutants. And the Anyang Environmental Protection Bureau went to the factory and said, okay, you have to pay a fine because you're emitting all these pollutants. And the Anyang, and this factory said, well, we may be physically located in Anyang, but you have no jurisdiction over us because we are under the Hunan provincial government. So we're a provincial level unit, and you guys can't tell us what to do. Who are you? You're just Anyang. So what the Environmental Protection Bureau had to do was to go up, the Anyang city government had to go to the Hunan provincial government and say, listen, please tell these people to stop polluting, or to pay the fines, at least, that they're supposed to be paying. And that, indeed, ultimately was what happened, but it didn't need to happen. Some other solution could have been arrived at, and certainly the solution that eventually was arrived at wasn't based on the law. It was based on this kind of negotiation between the center, between the higher level government and the lower level government. Well, that brings us to another very critical aspect of the legal order, and maybe I'll just finish up with this because I see I only don't want to take more than half an hour or so. And that's the relationship between the center and the provinces, a very important part of China's legal order. Now, formally, China is a unitary state like France or Japan. It's not a federal state like the US or Canada, so local governments have no exclusive reserve of protected powers. So China does not accept the separation of powers horizontally, between executive, judicial, legislative, whatever, what have you, and also the political order doesn't accept the separation of powers vertically. That is, the center, one national government does some things, and local governments have certain other protected areas. But there is a kind of a de facto separation of powers, simply because, of course, the central government can't do everything. They don't have the informational resources to keep track of everything. So basically, as I mentioned before, a lot of the governance of China takes place through the vertically integrating hierarchy of the party, but at any given level, local governments, units of local government tend to be responsible sideways and not responsible upwards. So even though China is not formally a federal state, even though formally it's a unitary state, in fact, sometimes their local governments may have more de facto power than local governments, even in a federal state, because this notion of horizontal accountability has been formalized. It is a matter of actual fact and not only in theory but also in fact, that if you are the local court official, if you're the local police official, the people you have to make happy are the party people at your level. It's not your superiors in the bureaucratic hierarchy. And so when one's dealing with any particular set of rules or any kind of hierarchy, one has to know who are these people responsible to. It makes a big difference. Back in the 1980s, let's take customs, for example. Now, do customs rules mean anything? Who do we have to keep happy if we're a customs official? Back in 1985, essentially the entire government administration of Hainan Island, the party, the government, and I have to say naval units as well, were all involved in a gigantic smuggling operation. They smuggled in 90,000 Japanese cars, about 3 million television sets for resale to the rest of the country. Now, where was the customs in all this? They were, I see nothing, I see nothing. It was all going through right under their noses. And why? Because the customs officials were not vertically accountable. They weren't responsible to their superiors. The state was losing all this, terror of revenue. All this smuggling was going, completely disrupting the state's plan to, protect its domestic car industry and domestic television industry. But people in Hainan were making a lot of money, and the customs in Hainan had to listen to the local people in Hainan because they were horizontally accountable. Customs is no longer horizontally accountable. Customs is now vertically accountable. Same thing with banks. Up until 1998, state bank officials, again, were not responsible to their ostensible superiors. They were responsible horizontally to the local people. So one can imagine what would happen if the central government is trying to implement some kind of credit contraction, anti-inflationary credit contraction. They say to the bank, stop lending so much money. At the same time, the local party official is saying to the bank, lend some money to fund my pet project. What's the bank manager going to do? They're going to lend money to fund the pet project. And it was only the Asian financial crisis of 1997 that enabled the central government to change this system. So now we have much more vertical accountability in the banking system. Of course, local officials, the local governments, even in situations like this, still have a lot of ways of exercising a certain amount of control over local officials, because the officials, even if they owe their salaries and jobs to superiors, they still need jobs for their spouses. They need schooling for their kids. They need various things that local government can provide, and so local government can make life easy for them, or it can make life difficult for them. Going back to the court system, there was a judge who once complained in something that he published that whenever he made a decision that displeased local government, the next day the school bus wouldn't stop to pick up his kid. Another judge once complained that I guess there was a story about a judge who had this was in Fujian province, which is on the southeastern coast of China, just opposite Taiwan, apparently he made a decision that displeased local government. He found his daughter was transferred from her position in a coastal city to a position on a small, island off the coast, which was very isolated and I guess not a place you'd really want to be. So local and central governments then are always negotiating about what their relationship will be, and that negotiation is necessary. Each side has certain cards. Local government has information, and central government, if they really want to get something, often they can get it if they're willing to spend a lot of political capital to do it. But one thing that doesn't seem to make a big difference in all these negotiations is whatever the law might happen to say. To give you another example, there's a French supermarket chain, Carrefour, which engaged in very substantial expansion and establishment of chains all over China at a time when the rules said that supermarkets could, I guess, have maybe as only 3 or 4 branches, and they had to have central approval. Carrefour went to all these local governments and said, we're going to bring jobs, tax revenues, local sourcing to your district if you let us build a chain here. And the local government said, sounds good to us. So at a time when all the other supermarket chains were being, good boys and following the rules, Carrefour was brazenly breaking the rules and setting up these chains all over China. And everybody knew it. I mean, this is the Chinese government is able to do a lot of things, and it doesn't need a lot of high intelligence capacity to figure out that there's a huge supermarket going up somewhere, that you didn't approve. So it doesn't take a lot to figure this out. So clearly the central government knew what was going on. And yet this sort of thing was allowed to happen. Eventually, the central government said, well, we can't have this brazen flouting of our laws continue, So they said, I guess they gave Carrefour a very light slap on the wrist. Carrefour had to apologize, say, we're sorry, we'll never do it again. Of course, they don't need to do it again. They've already done everything they need to do, which is to get the jump on their competitors. But the central government really more concerned that its authority should be acknowledged than that its rules should actually be followed. Okay, well, let me wrap up. I told you at the beginning that this wasn't a detective story, and so you'd know from the start, who done it or what my basic message was. And the point I've been trying to make is that although we can observe that the Chinese legal system is different from our own in many ways, it's not always obvious how we should interpret these differences. So one way of interpreting them is to say that maybe the Chinese legal system is different from ours the way a caterpillar is different from a butterfly, or the way an acorn is different from an oak tree. A caterpillar doesn't look anything like a butterfly, but we nevertheless, interpret the changes of a caterpillar in terms of the ultimate butterfly that it's going to become. And so, as I mentioned at the beginning, I guess the problem with this, as I see it, is that it assumes that change in all legal systems can appropriately be interpreted as development in a particular direction, a development leading towards something that looks like our own legal system at the end. So, we're not bothered. We can see very clearly that the caterpillar doesn't look like a butterfly, and yet at the same time we say, aha, but it's turning into a butterfly. And so that's how we interpret the development of the caterpillar. But we have to remember, if a caterpillar doesn't look like a butterfly, well, a St. Bernard doesn't look like a butterfly either. And then if we're looking at the Chinese legal system, how do we know whether we're looking at a caterpillar or a St. Bernard? Well, there's no foolproof way of answering this question. But we always need to be asking it. And so that's the point, really, of what I'm trying to say today. And maybe in typical law professor fashion, I'm going to suggest that the important thing is not how to answer the question, is Chinese law kind of truly fundamentally different? Because there may be no unvarying right or wrong answer. The important thing is to know that the question is out there, and then how to think about answering it. So let me stop there, and I'd welcome any questions or comments.
How does the Chinese perception of legality influence their adherence to legal standards in international institutions?
Yeah, that's a very good question. I think one might ask that about any country, I suppose. I think international law.
If you could repeat the question so it can be recorded.
Oh, I'm sorry. Okay. The question was, how does the Chinese perception of legality influence China's, I guess, actions in the international sphere, or at least its adherence to treaties, or its view about treaties and adherence to treaties? Is that accurate? Okay. A good question. Let's see. I don't think it has that much effect, and here's why. Because in effect, you play the game that you have to play, or that you're required to play. And in the international arena, in a sense, states have to play the legal system game. In other words, no state, in China included, says international law doesn't matter. They will always say, yes, we are following international law, and they will cook up some reason, of varying degrees of plausibility to explain why they're following international law. Very rarely, I think, will a state say, no, we don't have to follow international law. We have more guns than you do, so forget it. States just don't do that. Everybody accepts that you have to play the legal system game. Domestically, the state doesn't have to play the legal system game, and so it doesn't all the time. With respect to, when the Chinese government is presenting itself to the outside world, though, even about its own activities, then it accepts that it has to play the legal system game. So, the Chinese government will never, I think, say, yes, we are acting contrary to our own law, or something like that, domestically, when they're criticized by human rights, say, activists for doing so. They will deny that the violation is there, rather than say, hey, this is just the way we do things. You don't like it, it's a tough luck. So does that answer your question? Basically, the answer is not very much. I think there's a disconnect.
It seems like there's a lot of energy devoted to negotiations. Let's say the child child support payment needs to be at this level versus this level. Are there people employed as negotiators as well as judges and so on who go out and kind of then work out how this thing will? I particularly really want to look at that.
Yeah. Again, the short answer would be no. Basically, enforcement has always been a bit of a difficult issue for Chinese courts, and especially since economic reform. The traditional role for Chinese courts, and again, when I say traditional, I mean traditional socialism, 49 to 79, they did basically two things. One is they put the final, imprimatur on criminal sentences, and the other was they handled small-scale civil disputes. You needed to get a court judgment to get divorced, so that has to go through courts. Inheritance disputes, minor, boundary disputes or something like that. So they handled little things. They did not handle any matters involving state-owned enterprises, basically, because that's just not within their jurisdiction. Why would some low-level official be able to tell some high-level state-owned enterprise manager what to do? And so this is unsurprisingly where we find that they run into enforcement difficulties, even in those days, because they're telling this, in this case, they did purport to get involved kind of in state-owned enterprises and tell these people what to do. And unsurprisingly, the state-owned enterprise manager had the same reaction as this factory here. They said, "Who are you? Get out of here." So when a court is deciding a case, one thing that they traditionally would do then is to think about just how enforceable is this case. And very often then the ultimate judgment might have been watered down already, even before it was issued, by the concern that it wouldn't be enforceable. And this again goes back to the issue of how are Chinese judges rated. Actually, we don't know a lot about that. There's a colleague of mine at Washington University who's now working on a paper on looking at the incentives of judges. But we know that they also, like other government officials, have these sort of objective indices of how well they're doing. And one is the number of cases they hear, but also one is the number of judgments that go unenforced. And so if an unenforced judgment is a black mark on your record, wouldn't it be better not to issue the judgment in the first place? And in fact, not even to take the case in the first place. So we would find that judges would be thinking about this when they're issuing the judgment. Now, the system tried to come up with a cure for this by separating the case process into basically three stages. There'd be one heard by different groups of people. The first stage is when you decide whether to accept the case in the first place. The second stage is when you hear the case and come up with a judgment. And then the third stage is when you have enforcement. And these were supposed to be done by different groups of people in order to at least reduce this kind of, discounting that I just talked about. So in terms of what happens when you have a strong defendant that's saying we're not going to pay, what kind of negotiation goes on, I mean, ideally that shouldn't affect the judgment. It would just affect what you do when you go to enforce it. Oftentimes, I should say, many judgments go unenforced not because the defendant is especially strong or the courts are especially weak, but simply because the defendant maybe has no money. And that's true here. When I was doing my paper on Chinese judgment enforcement, I tried to find out what kind of research do we have on enforcement of judgments in the U.S. How good is it here? Because we just have some very impressionistic, intuitive idea. But I couldn't find much research, and the research I did find suggested it wasn't very good. Certainly in small claims courts, they have typically warned plaintiffs, don't be expecting very much. If to the extent they don't have specialists doing any kind of negotiation like this.
Mm-hmm. With your presentation seems to be that you have different bureaucratic structures at horizontal levels dealing with each other. Mm-hmm. What about the personal content in this? The idea of reciprocity among individuals, that they know each other, one has already made a judgment in your favor, and therefore maybe now you're supposed to respond in a similar way. Those and community standards itself, which says that we don't think that judgment is a judgment that anybody takes seriously here. Mm-hmm. Outside of the bureaucratic to the personal.
But what's the question?
what I'm curious about is not so much bureaucracies dealing with each other,
Yeah.
but a judge dealing with an individual in another bureaucracy or dealing with the community itself. And the judge is hearing that in this head-on, we don't do that. That, you know, your judgment would not be accepted because the community doesn't think it's just.
Well, things like that happen, certainly. I mean, there's many avenues through which judges can receive messages that a particular judgment would be unwelcome. I mean, there's the phone call from the party secretary that says, we're very concerned about this, not necessarily directly to the judge, but possibly to the president of the court or to some other, you know, superior of the judge within the court. Because although the Chinese courts, the way judicial independence works in China, in theory, in practice there's not much, but even in theory, individual judges are not supposed to be independent. In theory, at most, the court as a body is supposed to be independent. But there's nothing that would prevent, even in theory, the president of the court from, you know, giving some instructions to the particular judge hearing a case about how to hear it. And very often, you know, we do get stories. I mean, this field is full of anecdotes, many of which are quite funny. But we do get stories about, you know, local politicians calling up the court and saying, you know, do you guys want a new dormitory or not? You know, do you want to have BMWs or do you want to have bicycles? You know, to do your transportation work. So there is a lot of informal communication that takes place. Yes.
With the vertical and horizontal components, how are decisions made if somebody gets multiple orders with multiple different horizontal and vertical levels?
Okay. Typically, typically, there's only one, I guess, vertical superior that might be eligible to give you orders. Horizontally, I mean, you know who it is that is providing your appointment or paying your salary. You know, in other words, typically, it's quite clear when you have vertical accountability together with horizontal accountability. Typically, it's pretty clear which is the dominant one. You know, who has the appointment authority? I mean, let me give you an example. In the court system, we have you know, at the top, let's say center, province, municipality. Now we have the party hierarchy, we have the People's Congress hierarchy, and we have the court hierarchy. Now at any given level, the judges, say the chief judge of the court and the senior judges, they're appointed formally by the People's Congress hierarchy. So, you know, you have the National People's Congress at the center, the Provincial People's Congress, City People's Congresses. They appoint judges at the court at the corresponding level, formally. Now, where are they getting their ideas from, right? They are being, you know, in substance, that's coming from the party. It's the party organizational department that decides who's going to be a judge. You know, the instructions go to the People's Congress, and the People's Congress makes the appointment. So, you know, as a formal matter, it comes from here, and as an informal matter, it comes from here. And this is completely clear. I mean, everybody understands this. And so if a provincial court tells a municipal court, you know, to do something, and they're getting contrary instructions from here, it's completely clear they have to follow these contrary instructions that are coming from here. So there's not, I don't think there's frequently a lot of confusion. It used to be, if we're looking at state-owned enterprises, sometimes they used to have, this has been cleared up a lot more recently, but say back in the 80s, for example, it might be that you know, one governmental body had control over your inputs. This is in the planned economy. You know, another one had control over your outputs. Another one had control over your sort of blue-collar workforce. Another had control over your high-level management. You know, another had control over how much investment you got. Another had control over what you could price things at. So we did have this problem that was called in Chinese too many mothers-in-law, 婆婆多. That problem, I think, is not nearly so bad as it used to be. So typically, I think people know whether you're, which is the one that counts. Hmm?
Recently, actually a couple months ago, there was the crisis with baby milk within China.
Yes.
And my question was, is what role did the courts play in that decision, or did the parties still influence how that was going to be decided upon?
Okay, great question. And there's the answer implicates many things about kind of the unwritten rules about how China operates. The short answer is that the courts have played no role in it whatsoever so far. And the reason for that is not because there's anything in the law of China that says they can't do it. You know, if you market poison products that you know are poison and you cause people to die, the Chinese system does allow you to sue. And it also allows you to sue in large groups, because in cases like this, well, cases like this is not so important because every individual has large damages, and so it's economically just feasible, even for one person alone, to sue, because if they're next of kin or if they're the babies that haven't died, they have large damages. But sometimes you have mass tort suits where every individual's damages are not that great, and so you need some device to aggregate people's claims, such as a class action suit or some kind of ability to join people's claims together. All those things are pretty much available in China. So I mentioned before that Chinese courts have divided basically the case process into 3 stages. The acceptance stage, when the court decides as an initial matter whether they're even going to take this case and think about it. And then there's the trial stage, and then there's the execution stage. So all these cases, there have been parents who have brought these cases to court, but they have all been rejected by the court, in the sense that the court didn't say, we're going to try this case, and then they tried it, and then you lose. The court said, we're not even going to try this case. Go home, We're not saying you lose. We're not saying you win. We're just saying we're not going to hear this case, which is, as a substantive matter, it's equivalent to saying, of course, you lose. And they're doing this. Why are courts all across the country doing this? I mean, when everybody's singing the same song, you figure they must be looking at the same songbook. And so we can surmise that there are, internal directives coming down probably from the Supreme People's Court, but they are being told, if they needed to be told, they probably didn't even need to be told. It's obvious, in a sense, in the system that courts shouldn't be taking these types of cases. The state is very wary about, first of all, cases involving large groups of people, large being defined almost statutorily as 10 or more. So any lawsuits involving 10 or more people, they have special rules applicable to them, and some courts won't take them, period, at all, for any purpose. And then, of course, this thing implicates government officials as well, because if the chairman of the Sanlu company should be liable because she knew that this stuff had melamine on it and didn't do anything to stop it being marketed, then what about the government officials of the city of Shijiazhuang, who also knew that this stuff had melamine in it and continued to allow it to be marketed? So the state does not want this case in courts. They've kept it out, but again, entirely through unofficial means, not through any kind of official, transparent document.
Great feat to sort out the maze of the rule of law in China in 30 minutes. I guess I have 3 questions. You probably can consolidate this 3 into one in a short answer. One is, how do the legal community, the Chinese community, see themselves as a caterpillar or something else? Do they want to be a butterfly? To do with that? And finally, how do you see the prospect of rule of law under one-party dictatorship?
I only heard 2 questions. How does the legal community see itself, and
right.
rule of law under one party?
Where do they envision the rule of law, the legal system to be evolving in the future? And finally, how do you see it really? Can you have a true sense of the rule of law under the one party?
Okay. Your question about how does the legal community see itself, do they see themselves as butterflies, is interesting. And I think to a certain extent, yes, some people, certainly. And that raises the interesting question of whether, even if you're not a butterfly, you could become one by just thinking strongly enough that you ought to become a butterfly. You know, when we look at, say, the position of lawyers in the Chinese legal system, I mean, clearly what they do is very different often from what lawyers do in the US, but they look at the American lawyer kind of a model. They especially look at American lawyer fee system as a model. They love that. And so maybe if you have an ideal of what you ought to be, then maybe you will eventually go in that direction. So certainly that's, I mean, this is very interesting kind of cultural transmission that's taking place. So even though China in the past, you know, doesn't have this kind of shared history that results in a particular way of thinking about the place of law and legal institutions in the political order, nevertheless, people in China right now, you know, are looking around at the world and they're saying, here's an attractive model that we like. Some people are, you know, other people are not. On the one hand, you have the people who signed Charter 08, which makes no concession, you know, to saying, well, we want a socialist rule of law. So we just want rule of law, you know, no adjectives in front of it. You know, we would like democracy. We don't want any kind of adjective in front of it. And then you have, I guess it was, which official was it that just gave his speech recently about saying that these things are not for China? Do you remember? It was a propaganda official.
Oh, this is Li Changchun.
Yes, I'm sorry, Li Changchun. And what did he say? It was basically, these are all mistakes, you know.
We're going to prevent the Western multi-party system.
Yes, this is not for China. It's a big mistake, big mistake. So we have people now, just, you know, whose ideas are more appealing, who has more guns. Those are all, you know, interesting questions. Rule of law under one-party dictatorship. I guess I always feel uncomfortable talking about rule of law because it's such an abstract concept and it means so many different things to so many people. So I think the issue, I would like to look at the issue more as one of, you know, can a one-party dictatorship, is it in principle possible for a one-party dictatorship to operate with a legal system which imposes some kind of meaningful constraints on that government. I guess it's, in principle, possible. I don't think it's utterly impossible. So then we get to the more interesting question, was, is it possible in China? You know, under the current system, without some major fundamental change in the current system, is it possible for the government to operate under some legal constraints? I guess that question is almost tautologically answered in the negative. In other words, for that to be true, China would have to be much different for the government to operate under significant, you know, for it to accept the idea of playing the legal system game, you know, where it does operate, where it has to justify itself domestically in a serious way. And where courts or some body that sits in judgment on governmental actions that has some, you know, meaningful independence and ability to do that. Yes.
Like in your example with Carrefour, it was kind of obvious that foreign people get different standards, so they can expect to have different standards than I guess national. But that's for like an enterprise. So. My question or two, one would be, would it be any different for, say, a company from like a Southeast Asia, you know, because obviously Carrefour from French so it's a Western, so a lot of Chinese people is like, you know, West is good and East Asia, South Asia is bad, you know. So would that have a different standard or expectations, and then how does it apply to like maybe individuals from different countries?
You mean how does the legal system treat individuals from different countries or different companies?
That and also, like Carrefour brought on a lot of benefits to
right.
So then there was a slap on the wrist, different standard expectations. But for like enterprise, say from a small country trying to survive in China's market, or maybe individuals from smaller countries who won't get as much media attention, or say as an American who's convicted in China.
Yeah. Okay, it's hard to answer that question because it's hard to isolate the effect of nationality. The problem is that when we look at companies from Southeast Asia, you know, or other smaller countries, they just tend to be small companies also, because the big multinationals aren't from, you know, Bangladesh or something like that, right? They're not from Vietnam or from Hong Kong. The big multinationals tend to be, North American or Western European. So sometimes the issue is, are you a big multinational or are you a little company? Typically, little companies don't run into these problems. I mean, they do exactly what Carrefour did, but nobody cares because they're so small. Little companies very often completely ignore the foreign investment rules. I mean, in my own practice, I would run across this from time to time because you'd have some little fly-by-night company from Hong Kong or something that had set up a joint venture, in the founder's home village, and they just had contracts that were written on the back of an envelope in a Starbucks or something like that. But second of all, they have to worry about getting sued. There's a whole army of plaintiffs' lawyers out there waiting to see if you failed to cross a T or dot an I. And you can say all you want, well, this is just how it's actually done in China, and you can come up with a long theory about what the law really is as opposed to the law on the books, but how are you going to explain this to a jury in federal court? Very difficult. So I think American companies really have to be, above, like Caesar's wife, they have to be even or more Catholic than the Pope or whatever metaphor you like to use. They have to be very careful. In terms of how foreigners are treated differently, there's kind of an interesting dynamic, I guess. I mean, foreigners often do get treated maybe less harshly under the law.
My experience was
Yeah.
meeting like an Asian American.
Yeah.
It was kind of like, well, you're from America, but you are of ethnicity that's
Mhm.
from Asia. So then they were always confused of how to treat you. Not necessarily legally, but
Yeah.
I'm sure that applies legally as well. It's because it's so vague of what is specific in the specifics. So even in a market, it was like, well, are you American or are you Korean?
Right.
And that always caused problems. So in legal standpoint, what kind of things?
Well, there aren't that many rules that explicitly provide for better or worse treatment for foreigners. But there's kind of an understanding. In other words, that typically if you're a foreigner and you do something, I mean, if you go into the middle of Tiananmen Square and hold up a sign that says, Falun Gong is good, probably the worst that'll happen is you'll be expelled. If you're a Chinese citizen, a lot worse will happen than you being expelled from the country. I mean, they won't expel you from the country. They will send you to a prison camp. So, foreigners get a kind of, I guess Nancy Pelosi, didn't she do that several years ago? Something almost like that. So foreigners very often can do things that, the Chinese can't do.